humidifier.
Checking the moisture.
Checking the moisture. And here's my moisture meter. Yeah, I mean, it was a it was a version of how caregivers operate. You know,
and if the quality of that medicine's not there, then we just throw it away. Like in their minds, that's still like some dangerous thing, and to us, it's garbage. Like we should never give that to anybody, right? Like in their minds, that is like one thing. In our minds,
dangerous narcotic.
Yeah, it's.
Well, you know, there's I don't, you know, it's interesting because like when you're in a case like that, you not only do we become foxhole buddies, but it's hard for them to keep up the hatred.
Yeah.
Do you know what I mean?
I mean, year 5, like.
Do you see what I'm saying though?
Year 4, like.
But you know, like, and this is an experience that I go through where my clients will tell me about this horrific raid. And then by the time we get to court and start going through things, the prosecutors, blah, 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 blah. You know, it's like kind of civilized. Well, why would your client take? I'm like, but you don't know what they went through. You know, like they were expecting to be protected. You don't know what the things that they took from them. You don't know how they, you know, messed things up and broke up the house and blah, blah. You know, and this is something that really, and you just being nice and being blah, blah, is not going to cure this. We need to get, you know, it's not, but this is a conversation I have quite often. You know what I mean?
Yeah.
But what was interesting about this case was, you know, the persistence of not backing down, that you were going to take them on in their nonsense and with the story. You know, we weren't going away, and we were going to test them on every possible thing that we could and make them explain what they were doing. It, you know,
how many times did Judge Hattie tell us to go in the conference room and make sure your client understands the offer?
Oh yeah.
You know, and then, then we'd have to go back out. Like, you know, at some point, like these cards represent something, right? And if we have to educate these people on what that power that we have with these cards are, and how I could see maybe your point of view on the law enforcement side, at some point, like, this is to me what I am very passionate about. Like, I want to know where that line is, you know, and I don't want to be on either bad side of that. You know, at some point, you know, them knowing how this whole sequence goes, like, they did not want to go all, like, you know, what was the section 4, 10 days long?
10 day long.
And I'll tell you guys a secret. That line that Tony talks about, it doesn't exist. I think Earl will probably say the same thing, and that's what I've seen over and over again, is they target you, and they make any excuse, and then once you're in the machine, the idea is you've got to stay in the machine until they get their pound of flesh. And once they get their pound of flesh, you can leave.
Well, you know,
some people it's 2 pounds, Earl.
Yeah, Earl. Yeah.
There was an interesting legal issue because, you know, it shouldn't have gotten to this, but one of the ways that they tried to keep this thing going, and we had, there's different layers of the case. Like we challenged them on the traditional constitutional issues, so we got a chance to cross-examine all the players that were involved with those search warrants and how they got that stuff. Then there was an arrest without a warrant, so we got to force them to say how they had probable cause to arrest a warrant, which is really the same thing, but getting around the same issues, forcing the same. So as we're going through this and these layers, you see that there's nothing that's taking place, and all the blah blah that they tried to make of this. There's just nothing in these things that they're saying in the surveillance. You know, like we had him on surveillance on this day. What did you see? Well, he drove to his house. But this is how it's played out. This is emblematic. Police know they had the surveillance report. They just watched them. Was there something that happened that would suggest there was criminal activity other than him driving into his driveway? So things like that. So, but it's just some of the games that are played. And it's almost like a statement, well, we put all this effort in, and we followed him around, and we saw him go to his house. Come on, that's got to be something, you know. It doesn't mean anything, but I mean, look at it, we put the effort in. Come on, give it, you know.
It's part of the process.
It's part of the process.
But I think it's easy to see what happened. I mean, you had Grow Green, which was successful. You guys had a really booming online presence, and
pickup,
right?
They mastered the pickup and leave thing, and that was the whole thing. They're trying to say there's some activity,
right? And that was what caught the attention of law enforcement. And they said, well, we can't hit you for that, so we're going to target you for this. Right. And it's completely unfair. It's ridiculous.
When you see what they had and what they went on, it's actually kind of dangerous and scary. Okay, because what I'm saying is,
they have very
it shows the
powers.
power that they have
dangerous
and what
to
they get,
everybody.
and all these things that I'm saying, like, you know, No one's questioning the strength or weaknesses of the case. They got these warrants willy-nilly. They write these reports out of nonsense. The judge locks you up and gives you a high bond. We go through this whole thing in the district court, and the judge binds over Neil's client, and based on the statement, we get up to circuit court, and it gets thrown out because the statement's meaningless. I mean, just so this kind of stuff takes place, brought in, buried in there, stressed into it. Who knows what damage it did to him? Just in that, they twisted a statement on some notes to keep him in this case. It was insane. And when and only because we were able to unravel it with the exposure that they had the notes, and but it just shows you the brutality. But
and then let's assume for a second that Tony was in a position that he couldn't hire you.
Well, listen, it's more than that. It's more than that because it's a human being that's willing to hunker down in the foxhole and fight it in a battle of attrition. There's no other way, because the system will it's big. I came into work the other day singing I fight authority and authority always wins. That one? It's like it's the beast. It's the beast. It always and it's just waiting to take you down. And it's a machine. These courts do good
money.
Business. They do good business.
Yep.
And
revenue enhancement teams.
And so what I was getting at, the layers that we kind of got at them testimonial wise, and then we got into the medical marijuana, we kind of had been through what is it, and it was a lot of nothingness. But from a medical marijuana standpoint, there's a really interesting issue that we fought about, and I don't think it was much of a debate, but this is what they did. So there's 5 search warrants that were executed, and there was marijuana plants found at 2 of them. One was the place where Tony had his plants, and then the other one was where one of the other accused, the client, we'll just refer to him by the lawyers, the Rudoy's client, and he had an interesting situation because he had been a caregiver, and then they brought back that you can't be, the sunset rule with
any felony.
Any felonies, right?
Any
so he was transitioning from being a caregiver and had plants at a place and was trying to find accommodating the patients. One of those kind of things. And they don't send you a notice. There's no notice they send out. I mean, but nonetheless. So that was the only issue. Because at the time of the raid, he had lost his caregiver status, but had some extra plants, whatever. So, but they had previously been accounted for. Do you understand?
Yes.
So and nothing else. So what had happened was the charges of charging 3 people together, even though Rudoy's client
it's a DTO
was hit
3 people. Drug trafficking.
The Rudoy's client unequivocally had his plants there at this house. He's the one caregiver to patient, issue, and his cards there, his thing there. Tony at his place with his 68 of his carded for 72. All of his paperwork right there, and nothing.
Call me. My phone number's on the board.
Call me a phone number, right? It's all right there. It's all, like the statement, the notice. You can't leave. You trying to leave? Right. Okay. All right. Go ahead. You can go. Go. Call timeout. It's like we'll wait to serve when the guy runs across the court. Right? There you go.
Thanks, Bill.
I know, because champ's a champ. He's like, we're getting a game.
Veterans.
Tennis. All right. You're not leaving. All right. Where was I? What was I saying?
Got the podcast down.
Where was I at? That was a very important part of the story.
Oh, you were explaining, the different locations, and we were, going over some of.
Oh yeah, no, right. So, they charge multiple defendants in this case, three people, and despite all this unequivocal.
Who was the lawyer for the third one?
Neil Rockine, and Neil got his client out because of the statement issue. The district court found it to be credible. We got to the circuit court. It was tossed because it was nonsense, and that was the only link of what he purportedly said. But nonetheless,
he's the Rockweiler.
Neil did a great job. Neil was great.
That's what I hear.
It was actually Neil did a great job, as he always does. He's king, great lawyer.
I don't know if he's king, but
he's good. He's got some really. He's great. He's a great lawyer. I can't say anything but
he's a great guy.
And so what happens is they have the way they charge the case, and the prosecutors can charge any way they want to, right? The prosecutors are the bully in the courtroom. If they want to add a charge before you get to trial, they can do that. They can add them and take them away. They're the ones that are in charge of the charging, right? And the only way a judge can get rid of it is if some legal basis exists that has been brought to their attention. Even if a judge sees a bad search and you don't argue it, they can't do anything about it. They just can't summarily change the charge. So do you understand how much power they have? Yeah. So the choice of charging here, that they did it in this grouping, and then one guy's out, was really peculiar. But they didn't bend off of that. They just stuck with their story. So their story is that somehow there's a connection here, right? Well, along the way, Rudoy's client pleads to a misdemeanor, some kind of like
David.
Well, that's how he does it. We got to edit a lot of this. I realize there's some things that have been said.
We're live.
I'm talking about the video. All right. So as we go through this, and it goes, and David's client pleads no contest, but he takes responsibility for the plants at that location. So you would think.
I mean, at some point, what could have happened, even though he had the opportunity to take that, I mean, like, you know, they were effectively like, how long do you want to fight, right? How passionate are you and how committed are you for that side of it? And how much money can you fight with? And all these things. And if this were to go the other way, when you got to that versus taking this misdemeanor and just dipping out, like, I mean, you really, he knew what his fate was. And then after he did that, right, they said no probation, and then he still had 6 months probation.
I mean, everybody's got to make that.
They gave him a door to get out at the least harmful way they could. This, and you're right, and it's exactly like what you, and that was like 3 years ago or whatever, right?
Yeah.
Right? I mean,
2015, I think.
Right. So like a lot has gone on since then. Like we stuck in, and just to get clean break. Yeah. I'm saying like this is, they gave us the path out. Path out 20 times they offered us stuff.
What was the path out?
They offered us anything we wanted.
Anything. So
anything we wanted. They offered us noxious smell. They offered us the public health code with not washing your hands before returning to work.
No.
Anything.
Just
double parking. No, thank you. No, thank you.
I think at that point you kind of know you've got them by the balls. Oh yeah.
Well,
double parking.
I mean, you got to understand. Like in this sequence of events, we had a case dismissed on merit,
right?
And then they brought it back, and a little while later they dismissed it all. All right, so we had a lot more to fight. But this interesting issue that was going on with this Section 4, do you understand? Like we went in there, like we argued about the not usable marijuana, right. And then we said the plant count is his plants. They're his. That's how it is. There's no manufacturing count. He's in his numbers. What about Rudoy's client? Rudoy's client has nothing to do with it. Those aren't his plants. Those are Rudoy's client's plants, and he pled to a misdemeanor.
Yeah. He said those are his plants.
He said those are his plants. So assuming all that culpability. Yeah. So, and you would think that, but the way the charges read were the plants at these two locations that they were, trying to connect, which would have, combined the two is more than.
Yeah, twice.
Was and so this is
that's pretty slick. That's a good way to construct the lie.
But when you get to Section 4. It becomes there are questions of fact resolved by the judge as opposed to Section 8 will win that and get to the jury, or the judge could dismiss it.
Yeah, Section 4.
Because he can't, but Section 4 the court can judge credibility. So it also was the same argument about, we were arguing about the possession. Anthony's possession of the plants in there. What was the evidence that connected? Now this is how this stuff rolls out. I just want you to understand this. There's some really important legal principles such as possession, actual possession. I'm holding this microphone, or I'm wearing these shoes. This is my actual constructive possession. I got shoes in my closet at home. They're mine and not my wife's. Okay, so and the main principles are dominion and control. Like if I'm actually possessing, I have this, you don't have this, and at home they're in my dominion.
King of the castle,
right? But they're still in my part of the closet, not my wife's, as opposed to
and she's not allowed in my side of the closet,
right?
So.
And I am dominion of those things that go on my feet. And that may be about it.
She better not touch my shoes.
But anyways, so the idea here is that the plants that the Rudoy's client has already admitted to possessing, they're
his plants,
and that we've already established.
But somehow they're also Tony's plants.
No, but listen, he's already admitted that. That's fact one. We've gone through these layers of all these hearings. that there's nothing that connects Tony to this house other than there's an